Senator from Connecticut.
Thank you very much, Mr. President. I appreciate the remarks of my good friend, Senator from Oklahoma. Look forward to working with him on ways that we can try to come together to solve some of these big problems. I'm going to talk in a minute about the Affordable Care Act, which is probably the signature accomplishment of a Democratic Senate and Congress. Notable that the Affordable Care Act, for all its controversy, reduced the deficit, did not increase the deficit. Also notable that the signature accomplishment of the Republican Congress and the Republican Senate was a tax reduction bill that dramatically spirals the deficit out of control. $2 trillion of additional deficits in that provision. And so I share the concerns about the deficit. I find it curious that this Congress under Republican control has chosen to dramatically increase deficits, on pace for the biggest deficits in our legislative history, and enormous additional new elements of debt as well. Mr. President, I'm here, though, to talk about that Affordable Care Act because one of the things we talk a lot about here on the Senate floor is our mutual concern for people with pre-existing conditions. These are the 130 million Americans who are sick or who have a history of sickness. And if you listen to both sides of the aisle, you would believe that everyone is on board with the idea that we should provide individuals who are sick or have ever been sick with protections. And yet, actions do not meet words when it comes down to it in the United States Senate. Over the last 2 years, my Republican colleagues have spared no expense or effort to try to strip away protections for those individuals with pre-existing conditions that were in the Affordable Care Act. The repeal of the Affordable Care Act is the most obvious example of that. But this week, we will have a rare opportunity to take an up or down vote on this issue of whether we support keeping protections for people with pre-existing conditions in this country. The reason for that is that we are going to vote on a nominee to the Sixth Circuit Court who orchestrated, who directed the Department of Judiciary's attempts to take away protections for people with pre-existing conditions through the court process. Chad Readler filed a brief in a case brought by state attorneys general, all of them Republicans, to strike from the Affordable Care Act the protection for people with pre-existing conditions. Now, normally, when state attorneys generals come after the constitutionality of a statute, whether those are Republican or Democratic attorneys general, the administration, whether it be a Republican or Democratic administration, defends the constitutionality of the statute. This was an exceptional case in which these Republican attorneys generals were trying to take away protections for people with pre-existing conditions, saying that the ACA was unconstitutional. And an assistant attorney general by the name of Chad Readler stood up and volunteered to file a brief alleging that, in fact, the attorneys general were right. A rare, almost completely unprecedented example of the Department of Justice arguing against the constitutionality of a statute that had been passed by the Congress and signed by the president. Interestingly, before Chad Readler decided to file that brief, others at the Department of Justice refused. In fact, one lawyer left the Department of Justice because he wouldn't put his name on something so absurd as the brief that Chad Readler filed. Now, I'm not the only person who thinks that the arguments in his brief, trying to strike down those protections for people with pre-existing conditions, was absurd. In fact, Senator Alexander read Readler's brief and said that the arguments in it were, quote, as far-fetched as any I've ever heard. That's a Republican senator. Now, the consequences of the judge following the recommendations of Chad Readler were catastrophic. In fact, the judge struck down the Affordable Care Act. That order has been held in abeyance temporarily. But the consequences of the Readler brief would be that 133 million Americans would lose their protections from higher rates because they were sick or had been sick, that 20 million people who had insurance would lose it virtually overnight. Now, admittedly, the Readler brief didn't agree with every single element of the Attorney General's lawsuit, but enough of it such that it was very clear the administration was weighing in on the side of the petitioners. Almost immediately after filing that brief, he was nominated to serve on the appellate court, sending a very clear signal to all of those in the administration that if you take a leadership role on trying to strip away protections for people with pre-existing conditions, you will be rewarded. In this case, rewarded with a lifetime appointment. So we are about to vote on the architect of this administration's legal strategy to try to undo the most popular, most important protections in the Affordable Care Act. And it represents this rare opportunity to understand where senators stand. It's super easy. It takes no political risk in order to stand up and say that you support protecting people who are sick and making sure that insurance companies don't jack up their rates. As it turns out, it's a little bit harder to actually back up your words with actions. But this one isn't that hard. Voting against Chad Readler isn't that difficult, in part because Senator Brown, who's the senator from Ohio that did not sign a blue slip for Chad Readler's nomination, has made it clear as early as 10 minutes ago that he is willing to support and sign a blue slip for a mainstream conservative nominee. In this case, Democrats aren't saying we want a nominee to the Sixth Circuit that isn't one that could be charitably described as a conservative nominee. We just don't want a nominee who has made his mark trying to tear down protections for sick people in this country. But that's what happens when you get rid of the blue slip. Senator McConnell and Senator Grassley have gotten rid of this decades-old protection to try to make sure that nominees to the federal bench, to the appellate bench in this case, have the support of their home state senators. And when you do that, you tend to get a little bit more mainstream nominees. Now that the blue slip is gone, now that Senator Brown has no ability to weigh in on individuals who are going to be making law in his state, you get a much more extreme nominee like this. So let's see what happens. I hope that there are some Republicans who will stand up and decide that they're going to put their votes where their mouths have been on the question of protections for people with pre-existing conditions, but at the very least, the American public will get to see where we all stand on this very important question in a matter of hours. I yield the floor.